Our first item that we want to talk about here is the district court ruling. So this goes back to the state of Texas, and it's the Texas Bankers Association versus the CFPB. Now, you might say, "Gosh, we've heard of that before." Well, that was the one that we talked about prior was the one that had to do with whether or not the CFPB's funding structure was constitutional. That's been taken care of by the Supreme Court. Okay, there still was a secondary issue as it related to how the CFPB went about writing the regulation that we're all talking about relative to implementing Section 1071. And the things that were called into question in this court case that still remains with the state of Texas is the abuse of agency discretion, whether or not the CFPB did that, whether or not they failed to fully consider the effect of the regulation with the way they wrote it, and then they're trying to claim that there was an inadequate cost-benefit analysis applied and conducted by the CFPB. So those were the arguments that were made on behalf of the TVA against the CFPB as it relates to the writing of the regulation, not the law itself, okay, the writing of the regulation that was put into place to carry out the law, the things that we've been talking about in this implementation group. To give you a little bit more on that, okay, the law itself only identified 13 specific data points. Okay, what's being done is that if you go to letter B2, additional information there, the law also states that the CFPB has the discretion to go beyond that with what's necessary to fulfill the fair lending requirements associated with 1071. So they're trying to argue they went too far, even though they were given discretion. And so that's a fine line somewhere, right? Here's what's happened. The district court in Texas said, you know what? We may not agree with the rule, the final, or the not the rule. We may not agree with the regulation that was written to carry out the rule. In fact, you can read my bold information there in letter C. Hey, the judge even kind of says, yeah, this regulation seems a little quirky, but you know what? It's not unlawful. They didn't step over the line. And so the judge actually ruled in the CFPB's favor, which means just what we've been saying all along, we need to keep the implementation train going forward. Now, what you're all probably most interested in is what's not in the book, and that is that you're going to, if it hasn't already happened, it hadn't as of yesterday when I looked, but there's very likely, I can guarantee you, there will be an appeal on this. Now, you might say, why didn't the appeal happen right away? Because it's about a month old. There's some I's that had to be dotted, T's that had to be crossed with respect to the way the courts work. And long story short, you're going to see an appeal, almost a guarantee, with the Fifth Circuit Court here in the coming days. Now, does that mean that the regulation is going to be done away with? I'm not going to bet on either side of that. What I can tell you that it would take an act of Congress to change the law. And that's not, they tried that, it didn't work. I know we got an election coming. There could be some things blowing in the wind there possibly, but at this stage, the recommendation is keep moving forward. The law is the law. The regulation, they could call some things into question there based on this, but we're a ways out on it still. So stay tuned. There just seems to always be something blowing in the wind with the regulation and or the law, and we still seem to have to be going forward with it.